Okay, let's go.
Hey you guys, welcome back for another video. Make sure as you come in you like and share this video. Also, if you haven't subscribed, make sure you hit that subscribe button. Also, make sure that your notification bells are set so you are notified every single time I drop a new video. Hey you guys, welcome back. Thank you guys for joining me. Today we are going to have a quick video, maybe 15-20 minute video, and we are going to briefly go over the state's petition to the state of Illinois' petition to the Supreme Court of Illinois about their petition to reverse the appellate court of Illinois' decision to reverse the pretrial detention for Quadajah Holly Johnson. We're definitely going to go into depth. But first, just let me just go ahead and remind you about the Carmelo Anthony case. You guys know that trial is scheduled for June the 1st, and you know the judge has implemented strict security courtroom rules as well as media restriction, and that's due to the massive public attention and outrage that the case has taken. So you guys know the prosecutor has accused Anthony of unaliving Metcalf at a track meet during a confrontation that they were having, and they're going to try to prove first degree while the defense is expected to claim self-defense. So we're going to see how that goes and see how that comes. And again, that starts June the 1st, and I'm pretty sure the first week or so will be mostly jury selection. All right, but meanwhile, we're going to get into the case that is currently happening right now in the Supreme Court, where the state of Illinois just dropped their petition yesterday, May 18th, to the Supreme Court of Illinois. Now, you guys, basically, your question is, will the Supreme Court even take the case? That's a question. The second question is, if they take the case, will they reverse the appellate court's decision to release Quadajah Johnson on a pretrial release while her trial comes up? Those are the questions the public is asking. But if you deep dive, this particular case is probably a whole lot bigger than Quadajah Johnson, because the outcome of this one is probably going to change how the appellate court rules during decisions as pretrial release. Are they narrowing down what is more important over something else? But it's going to take a big impact, just not on this case, but future cases to come. And I'm going to break it down and show you how. So let me give you just a brief summary. See, everybody thought this case was just another tragic relationship dispute that turned deadly, although it was. But now, researching and looking at it, it has become one of the biggest legal tests yet under Illinois' Pretrial Fairness Act. Now, Quadajah Johnson, she's accused of shooting Romika Blackman in broad daylight near a Chicago school. And this was after a confrontation tied to a, you guys know, complicated, personal, to me, triangle relationship. Prosecutors say it was unaliving, first-degree murder. The defense says it was self-defense after months of alleged threats and stalking allegations. An appellate court shocked a lot of people when it ruled Johnson should be released before trial. But now the state of Illinois is saying, yeah, hell no, not having him. Taking this battle all the way to the Illinois Supreme Court. And the real question is not just should Quadajah Holly be released, but actually the bigger question is, how dangerous does someone have to be before Illinois courts can legally keep them detained before trial? Because depending on what the Illinois Supreme Court decides, this case could reshape pretrial detention across really the entire state, really across many states. And one dissenting judge, you guys know there was one dissenting judge that didn't agree with the other two judges. And he said something. He says the law does not require waiting for a second dead body before recognizing danger. So, did the appellate court protect constitutional rights? Or did it dangerously narrow the definition of public safety? So let's get into it. But first, you guys, let me give you a backstory. If you're not familiar with the Quadajah Holly case, let me give you a backstory.
This is how Romika's morning started. A note that she wrote to her 6-year-old son, Carlos Jr., in his lunchbox before dropping him off at school. Quote, "Happy Monday, son. Today is a fresh start, and you can start off strong. Always remain yourself. You're the coolest, smartest, funniest kid I know. I love you so much, and you make me so proud."
Carlos may be hurt for the rest of his life, but we make sure he see rainbows in his class.
It's the last memory he'll ever have of his mother. Prosecutors say on September 8th, after Romika dropped her son off, she didn't know her child's father, Carlos Smith Sr., had parked nearby to switch cars with this woman, 31-year-old Quadajah Johnson, a woman who he also shares a baby with, a 6-month-old. The infant was in the back seat with them when they pulled up. In court records, prosecutors said the two women, they saw each other and got into a verbal argument. A witness driving by told police he saw Quadajah Johnson advance towards Romika while Romika stood stationary with her arms crossed across her chest. Another witness waiting at the bus stop sees Carlos then begin swinging the car door on Romika, attempting to close her own car door on her. Quadajah then approaches them. Romika gets back out of the car before Carlos then puts Romika in a chokehold. She then breaks free. Witnesses then say Quadajah got a gun from her car, walked towards Romika again, but this energy, it was different. She fired the gun multiple times, striking her in the face with a pause between the first shot and the shots that later followed.
You shot somebody. What the f*** wrong with you?
For 3 months, Quadajah Johnson walked free, telling police it was self-defense. You could even hear her tell passerbys she had a restraining order against Romika.
I'm licensed to carry. It doesn't matter.
Despite them never meeting in person, a judge granted a no-contact order after Romika was accused of threatening Quadajah and her family. It was later revealed that Romika was never served it, though.
Justice for me! Justice for me!
Months of anguish turned into relief on December 3rd.
I just want to say thank you, Lord.
Chicago police finding probable cause to arrest Quadajah Johnson, charging her with first-degree murder.
I thank the world because the world helped me and God. I thank y'all so much.
Fox News Chicago reporter Tia Ewing talked to Carlos Smith after Johnson's first court appearance.
You were there. What's your reaction to what you heard came out in court today?
When I heard it, I'm just looking, it was unbelievable, but I was there. And I know for a fact none of that happened, how they just explained it. But my truth will get out here, and I hope everybody understand. That's really it. I can't even say too much right now, because it's just gonna feel like I'm going against them, they going against me, we just going back and forth. But the truth is gonna.
So as you guys know, on December 3rd, 2025, Quadajah Holly Johnson was arrested and charged with first-degree unaliving of Romika Meeks. Now, during this time, the state said that there was a confrontation between Romika Meeks and Quadajah Johnson, in which Romika Meeks came and pulled up or approached Johnson and Carlos Smith. During the confrontation, at some point, Carlos Smith had Romika Meeks in the chokehold. Allegedly, when Romika Meeks was able to release herself from the chokehold, at some point during that time, Johnson had went back to her car to retrieve a firearm and approached Romika Meeks again and fired her firearm allegedly 2 or 3 times, which resulted in her death. She was out for 3 months before. She was out for 3 months before they did arrest her. So the state claims that she was a menace to, I guess, a danger and menace to society, and that no amount of conditions would mitigate her being out or be sufficient for her to get out on pretrial release. Of course, the defense claimed that it was self-defense. They claimed that she had a protection order against her that would resulted in a default protection order. She also said that she had been stalking and threatening her prior to that incident, and that Quadajah Johnson, boy, I'm having a lot of trouble with pronunciation, right? Quadajah Holly Johnson was in fear for her life as well as her baby's life. Now, there's of course a lot of questions about retreating, not retreating. Did she have to retreat? Blah, blah, blah. Despite that, the judge said no, she was not going to be released, which was Judge Clancy on December 3rd. He's like, no, she's not going to be released. She is going to stay detained. However, the appellate court came in and reversed the decision to have Quadajah Johnson be released for pretrial detention, saying that they felt that mitigating conditions could lessen the risk of her being out. And also another one was when she cooperated with police after the incident. She owned her firearm, claimed that it was more of a personal attack than it was a threat to the community. Also made her pregnancy a reason for releasing her. Also saying she didn't have any arrest. Just basically, you know, making it more of a personal thing than a community thing. And you all also know that there was a judge, there was a third judge, there was 3 judges. 2 of them wanted to release her. The second one was a dissenting judge that said, yeah, no, I don't think you're taking the matter as serious as you should. Now, this is what the dissenting judge had said. The dissent argued firing multiple shots near a school and children demonstrates serious danger. A personal dispute does not mean someone is no longer dangerous, and the majority minimized the severity of the conduct. Now, remember, when he says majority, he means the other 2 judges. The dissent also stressed electronic monitoring and firearm bans cannot necessarily prevent future violence, and the law does not require a second dead body before detention is justified. Well, due to this decision and the discrepancy being that it was not a unanimous decision with the appellate court, the state took advantage of that, and they said, well, we're going to file a stay to make sure that the appellate's decision is paused until we can file a petition with the Supreme Court to reverse the decision of the appellate court to have Quadajah Johnson remain in custody until her trial. And that's exactly what the state of Illinois prosecution team did on May 18th, 2026. They filed a petition for leave for appeal. In other words, they filed a petition to request of the Illinois Supreme Court to reverse the decision of the appellate court to release Quadajah Johnson Holly on pretrial release. The state had the following arguments as to why. The state argues that the appellate court wrongfully treated the fact that the situation arose from a personal relationship and the fact that the defendant has no criminal history, treated as though it justifies for an automatic release. The state argues that a violent crime, even stemming from a personal situation, justifies detention even if the parties knew each other and even if the defendant had no criminal history. The prosecutors say that the appellate court improperly raised the burden of proof by ineffectively requiring that they disprove self-defense at a detention hearing. State says detention hearings are preliminary hearings, not full trial, and they should not be required to disprove or defeat self-defense in order to prove that a defendant needs to be detained. The bottom line is, y'all, the state of Illinois is asking the Illinois Supreme Court to review the decision of the appellate court, review the facts, review the reasons, review it, and make a sound decision. They are also asking them to clarify how judges should use the Pretrial Fairness Act. In what context should that use? And how narrow and how wide the act should be used. But most of all, to potentially reverse the decision of the appellate court for Quadajah Johnson's pretrial detention. So you guys, in conclusion, how do you think the defense is going to respond to the state's petition to the Supreme Court? How do you think that the Supreme Court is going to handle it? Do you think the Supreme Court is going to take the case? And if they do you think that they're going to reverse it? Well, I will tell you, what do I think the chances of the Supreme Court even taking the case? I think is very strong. And the reason I think is because there was such discrepancy in the appellate court judges, and it was a split decision, which means that they had some type of discrepancy about what the law says and what it represents and how it should be implemented in a case such as this. So yes, I do think they strongly will take it, but there's always the chance that they may not even take the case. But anyway, comment down below and tell me what your thoughts are and tell me what you think. And continue to join me as we cover the Carmelo Anthony case when it comes up June the 1st and as we continue to cover this trial. Thanks again. See you guys later.